There are 5 things that you must know if you are a defendant in a criminal case. As a criminal defendant, there are going to be certain points in time where you are going to have to make a decision. Do you keep fighting? Do you accept a plea deal? Do you go to trial? Do you not? Do you accept the prosecution's offer, or do you reject it and ask for one from the judge? These are all big decisions that you are going to have to make, and there are 5 things that you need to understand in order to best make these decisions. My name is Veronica. I am a criminal defense attorney here in Los Angeles, and I help people who have been arrested put their criminal cases behind them so that they can enjoy their lives and their freedom. And again, in this video, we will be going over those 5 things that you must know as a criminal defendant in order to make the best decisions in your case. So the first thing is that you need to understand, for the crime or crimes that you have been accused of, what is the absolute worst that you are facing. For example, for first-degree murder, perhaps it is life in prison without parole. For misdemeanor, maybe it's a year in jail and you would be unlikely to serve more than 10% of that. You need to know basically what the stakes are. And of course, just because that's the worst case scenario, sometimes people will hear, oh, I'm facing, 6 years in jail if I get convicted of a 273.5, and they think, oh my God, that means I'm going to go to prison for 6 years. No. In fact, that's usually in those cases very unlikely. What it means is that is worst case scenario. So number 1 is understand the stakes. Number 2 is you want to understand the typical outcome for these types of cases. And when I say these types of cases, I don't mean just that charge. I mean with your criminal history, with the specific facts of the case, such as if it's some kind of violence alleged, injuries. That's going to be important. How bad were the injuries? You need to know what the outcome is going to be. So let's say it's a first-time domestic violence case. I handle a lot of these cases that is charged as a felony, and you are facing up to 6 years in prison. Okay, most of those cases, if it is your first time, you have no priors, and the injuries are not really bad, most of the time that can eventually be reduced to a misdemeanor, and you get classes and probation. So even though it looks really bad at the beginning, in your case, that's what most of those cases can get. And it doesn't mean at the outset. I mean, this is after putting work into the case for quite some time that we can get this outcome. But that is, I would say, for my case, is the usual outcome. But for example, let's say it's someone who has 2 strikes against him already. This is his 5th domestic violence case, and the injuries were horrible, maybe like a broken bone or something. Okay, well, it's not going to be probably a misdemeanor. I mean, it depends on the facts of the case. Maybe we can get all the evidence thrown out on some kind of technicality. It really depends, but based on those facts that I just mentioned, you are probably looking at some kind of imprisonment. Maybe it's going to be jail, maybe it's going to be prison. It really depends, but for those facts, the usual typical outcome is not going to be the same as someone who's first-time DUI or first-time domestic violence with no criminal history and not bad injuries. You also want to know, as number 3, anything about your case that makes it worse than usual. So, for example, if there are extensive injuries, you want to know, okay, that looks really bad. Or maybe you don't have any convictions on your record, but your ex-girlfriend used to call the cops on you all of the time. And the prosecution has noticed that, and they say, okay, this guy's an abuser. Even if she would just call, every time you guys got into a fight and nothing was actually happening. There are all kinds of factors that can potentially make it worse. Maybe the neighbors have called multiple times. But you want to know that too, so that you can see, okay, here's the usual outcome for this type of case, but do I shift, maybe this way a little bit to making it a little bit worse based on some factors. Another example could be that the alleged victim in the case really wants the case to be prosecuted and shows up to court, cries to the prosecutor. That is going to make it a little bit worse. You also want to know anything about the case that makes it a bit better. So perhaps there is some evidence that could be suppressed in the case. That is going to make the case better. Even without that evidence being suppressed prior to that, if the prosecution realizes, because your attorney brings it up, hey, some of this evidence could potentially be thrown out, that is going to make your case better. Maybe the victim, and this is really common, does not want the case to be prosecuted. Usually that will help a little bit. It doesn't mean that the case is going to be thrown out. It's not just based on what the victim wants, but it definitely helps your cause. And as I mentioned in an earlier example, perhaps the injuries are not very severe. Maybe there's just a little scratch, something really minor. Perhaps your story has been consistent all along. Perhaps you did talk to the police, which could in some cases make it worse. But in this case, your story makes sense. You repeated it multiple times. That can potentially make your case a little bit better. And finally, number 5, you also want to find out what, if anything, can you do to try to make your case better. So sometimes I will send my clients to classes, anger management, therapy, substance abuse treatment. Sometimes I'll send them there and tell them, okay, go take those classes. Sometimes we will need to get a psychological evaluation. Sometimes there's something an investigator can do, and we can get an investigator appointed at no cost to the client in Los Angeles County. Sometimes I tell my client has no job and has some kind of history with drugs. And I tell my client, all right, you need to get a job. I can't go to the prosecutor and say, you don't have any job. You are not going to school. There's nothing here. Go and find a job. Go apply right now or sign up for school. Figure out something. And figure out what you want to do with your life. That's common in kids maybe 18 or 19. Maybe they just finished high school. Maybe they dropped out and they're not really doing anything. I want to show the prosecutor, okay, this person is not just planning on having a life of crime. This person is actually, they're confused as a teenager a bit, but they're getting their life on track, headed in a positive trajectory. So you want to find that out. And all of these 5 things are things that you can and you should be able to find out from your attorney. If you have the public defender, it may be a little bit more difficult because they are limited in the time that they can spend. But you should be able to figure out, okay, what are the charges against you? And you can look that up. When you talk to your public defender or your attorney, make sure that you really pay attention to what they're saying and take notes on it if you think you're not going to be able to remember. Make sure that you ask these questions, and when you get an answer, you write it down, you commit it to memory, so that when you're making a decision later, when your attorney tells you, hey, we got this plea deal, and you think, okay, wait, but this is my first time, domestic violence case, not bad injuries, why would I go to prison for this? You have that in your mind, and then you can ask that question, wait, I thought my case wasn't much worse than usual. Why are you saying I should take that deal? Or what do you think? Do you think I should take the deal? So all of these are things to keep in mind. I know some of this may sound really obvious and logical, and it is, but I think when people are faced with these kinds of decisions and they don't have a lot of time to decide, sometimes you're expected to decide on that same court date. You are stressed, with any kind of plea deal, there is some kind of consequence to it. Even if it's just taking classes, there's still a consequence to it. And you want to have all of this in mind. So as you're going through the case, you can already start to think about what your decision would be. What would you accept? What would you not accept? Do you want to take this to the end, to trial? And are you sure? Because there's a lot of risk involved there. But if you don't know, number 1, if you don't know worst case scenario, then how can you say I want to take it to trial? Anyway, I hope that this helps. If you do have an active criminal case in Los Angeles County, feel free to give me a call, or you can click on the link below to set up an appointment with me.